The chapter on tort law is extremely important. Typically, it is covered very thoroughly on my exams, and I will expect you to know quite a bit more detail with respect to this chapter than some of the other ones. And as you might expect, I will cover this chapter in a little more detail. Keep in mind that, as with all of the chapters, we're looking at general rules. We're not getting into all the details. This chapter is, in fact, the total content of this chapter is 2 semesters of law school. So you're looking at, and it could be more, but it's typically a couple of semesters. So you're looking at about roughly 90 hours of coverage in law school, and we're spending just a few hours of class time on it. So when I say we're covering just the tips of the icebergs in these chapters, in some cases we're not even doing that, but we're really just scratching the surface. Like other chapters, realize that these topics are matters of state law, and state law can vary greatly from one state to another. And so we're just looking at some general rules that typically are applicable in most states. A tort is a civil wrong. In chapter, I think it's chapter 5, we looked at criminal law. So we're looking at civil law here. And the burden of proof in civil law, remember, is merely a preponderance of the evidence, where the plaintiff has to prove more likely than not. And again, for those who like numbers, the plaintiff has to win. If you're looking at a total value of 100% put on the evidence, the plaintiff must prevail by 51 to 49, and it can be just that close. The plaintiff has to prove that what he or she alleges is more likely than not true. And in doing so with tort law, when you're looking at the elements of the tort, essentially what that means is that you have to prove each and every element more likely than not has occurred. The same act by a defendant can be both a crime and a tort. If an individual is merely punished criminally, that does nothing to compensate the harmed plaintiff. The defendant, through civil law, the defendant compensates the plaintiff for the damages caused by that defendant. One of the reasons that this chapter is particularly important is torts are all around you. Once you've covered the chapter, once you've read it, you'll start seeing things that go on at work, maybe even in your own personal life, that may constitute torts. And quite often, when torts occur, employers can be held liable. For example, if a tort is committed, let's say an employee, while acting within the scope of their employment, while performing their duties, the employee acts in a negligent manner and harms a customer. Under those circumstances, quite often the employer can be held liable. It's called vicarious liability, which will come up a little later in another chapter, but the employer can be held vicariously liable for the wrongs committed not by the employer, but by the employee. And again, typically, that's where the employee has been negligent while acting within the course and scope of employment. So the overall purpose of tort law is to compensate plaintiffs for the unreasonable harm that they have sustained as a result of the defendant's action, whether that defendant has acted carelessly or intentionally. Now that may impact the amount of damages. In fact, it would, depending upon whether the defendant had acted intentionally or carelessly, but I'll come back to that in a few minutes. Sometimes questions come up about what state's law might apply. For example, if I do something here, maybe I say something to someone in Arkansas, maybe I talk to an employer in Arkansas, provide information to that employer that is untrue about a former employee. I say something about an individual who has worked for me in the past, and maybe I make a false statement and it prevents that person from getting a job in Arkansas, then Arkansas law would apply. So typically, as a general rule, the law of the state where the tort has occurred is the state law that would apply. Now, the categories of torts, as I mentioned, you can have intentional torts, and we'll look at those a little later. You can have negligence, and the chapter addresses negligence first, so I'll spend more detail on negligence initially, and then we'll look at intentional torts later. And then you've got a third category of torts. These are typically referred to as strict liability torts, where the party who has committed that act can be held liable regardless of how careful they may have been. In addition to punitive damages being available for intentional torts, sometimes the party who's been injured suffers some far-reaching, unexpected consequences. In other words, the damages are far greater than anyone would have ever anticipated, given the action by the defendant. And the question comes up, for these far-reaching, unexpected consequences, will the defendant be held liable? And typically the answer is more likely than not going to be yes, if the defendant has intentionally caused this harm. If it was an intentional act, then where the plaintiff suffers some far-reaching, unexpected consequences, the defendant will be held liable for those damages. So the more culpable the defendant's conduct, the more far-reaching his liability will be. Now let's look at the tort of negligence. You've got 4 elements. All 4 elements must be proven, and must be proven by a preponderance of the evidence. You've got duty, breach, causation, and damages. All 4 elements must be proven in order to have a recovery for the tort of negligence. As a general rule, the duty is one, to act as an ordinary, reasonable, prudent person under the circumstances. You've got a duty to be careful, and the duty, the standard of care, the duty that you must adhere to is to act as an ordinary, reasonable, prudent person under the circumstances. And when you fail to live up to that standard of care, you have breached that duty. So a breach is simply where you fail to exercise the care of an ordinary, reasonable, prudent person under the circumstances. The third element, you've got to show that the breach of that duty actually caused the damages that resulted. Now, you've got a good bit in the chapter dealing with causation. I'd like you to focus on a couple of tests to determine whether a particular behavior in fact caused the damages. One is the but-for test, and probably the easiest way of expressing this is simply to say that you have to look at the act, and you look to see if the act is the cause in fact of another, when the second act would not have occurred but for the first. All right, let me say it another way. In other words, but for the defendant's act, the plaintiff's injuries would not have occurred. But for the defendant's behavior, plaintiff's injuries would not have occurred. That is referred to as the but-for test. And if it helps to just remember what's in the book, that's fine. Sometimes I'm going to put things in a little different wording. Whichever works for you is fine. I don't think I'll be saying anything. I certainly hope I don't say anything that contradicts anything that's in the text. If it does, if I ever do, I'll have to clean it up. But I just want you to know generally what the but-for test is. So again, you look at the defendant's act and you say, but for the defendant's act, plaintiff's injuries would not have occurred. And that would be an example of showing causation. And then there's sometimes situations where two or more causes concur to bring about an injury. And in those cases, typically courts will use what's called the substantial factor test. Courts will look to see, was this particular behavior, was it a substantial factor in causing the injury that occurred? So two tests to be familiar with, the but-for test and the substantial factor test. There's some information in there pertaining to proximate cause, and let's just keep this one simple. It's an idea that courts use to cut off damages at a certain point. For example, if there is a chain reaction, somebody does something, somebody fails to pull the parking brake on their car, the car rolls forward, strikes another vehicle, that vehicle rolls forward and knocks over a bag containing a bowling ball. The bowling ball rolls down the hill, strikes a baby carriage. The baby carriage, you see, we're talking about some series of events. Well, the courts will look at that series of events and just make a determination. Essentially, it's in a sense of fairness. They will simply cut off liability to individuals who were way down that series of events, and not allow them to recover against the party who initially put all that into motion, the party who's being sued, the defendant. All right, so just know generally what proximate cause is, and I'm not going to beat that topic to death. It's just applying a concept of fairness. And if you're generally just familiar with the but-for test and the substantial factor test, that'll be sufficient as far as knowledge of causation. I do have an item on there that's worth noting, negligence per se. Typically what that is it's a shortcut. Look at it as a shortcut method of proving duty and breach. The duty is set by statute. For example, if you've got a situation where you've got a law on the books, you've got a statute that states what the standard of care is. Maybe in each housing unit there must be a smoke detector, and so that's the statute. And maybe a fire breaks out in a building and people are injured, possibly even some people lose their lives. The question is going to come up concerning duty and breach. So if you can show that there was a statute requiring smoke detectors in each unit and there were no smoke detectors in those units, the statute was violated. In a lot of cases, that will be used as a shortcut method of showing duty and breach, and that's referred to as negligence per se. Now, there are a lot of requirements, certainly more than what I've addressed so far, but there are a lot of additional requirements, so this does not apply in all cases. For example, typically that statute has to provide for a criminal penalty, and if it does, then that helps towards a finding of negligence per se. It just makes it a lot easier for the plaintiff to show duty and breach. And keep in mind, that's all that it shows. You still have to show that the breach of that duty is in fact what caused the injury that occurred. And the last item is, or the last element of negligence is damage. The damages can take any one of three forms. You can have monetary damages, emotional damages, or physical damages. So even though I was not physically harmed, if I've suffered some severe emotional harm, that could well be sufficient to recover for the tort of negligence. The defenses to negligence. I have three, and I believe the book addresses all three. They don't do much with contributory negligence, and that's for good reason, because there are just a few states that follow contributory negligence as a defense, but some of those states who do allow for the defense of contributory negligence are neighboring Tennessee, so it's worth your at least being familiar with the defense of contributory negligence. Essentially what that defense says is that if the plaintiff is suing the defendant for negligence, and if the plaintiff is found to be even 1% at fault, even 1%, if there's any liability on the part of that plaintiff, if they contributed in any way to their own injury, the plaintiff gets nothing. It is a very harsh defense. It used to be the law of Tennessee. We used to be a contributory negligence jurisdiction, but we are no longer contributory negligence. We have a form of comparative negligence. And that's the next defense that I have listed for you to be familiar with. Comparative negligence can take many different forms. For example, you can have pure comparative negligence. And essentially what happens there is the court simply allocates, actually it would be a finding of fact on the part of the jury. The jury would allocate percentages of fault, maybe finding that the plaintiff, they find that the plaintiff was maybe 70%, well, typically it'd be the other way around, but it could be 70-30 plaintiff-defendant. But typically if the plaintiff is suing, they're going to be the least culpable of the parties. So let's say the plaintiff is found to be 40% at fault, defendant 60% at fault. Plaintiff is suing to recover $100,000 in damages. With a 40-60 split like that, the defendant generally would be able to recover, the plaintiff would be able to recover from the defendant $60,000. So 40% allocated to the plaintiff, 60% fault to the defendant. Plaintiff would recover 60% of the damages that they're seeking to recover for. Now in Tennessee, we have a modified form. In fact, there can be several ways that comparative negligence can be modified, but in Tennessee we have what's referred to as a 50% bar rule. The plaintiff is barred from recovery, prevented from recovering anything at all, if he or she is found to be 50% or more at fault. Assumption of risk. An assumption of risk can take the form of either being an implied assumption of risk, where maybe I attend an event, I don't sign any document, there's no acknowledgement of my accepting any particular risk, but merely by attending that event where certain risks are obvious, if it can be shown that I knowingly and voluntarily assumed that risk by attending that event, then the implied assumption of risk doctrine would apply. If I attend an event or participate in an event and am asked to sign a document, and that document may be referred to as an assumption of risk agreement, a waiver of liability, exculpatory clause, whatever you want to call it. As a general rule, if I'm asked to sign a document where I agree that I will not hold another party liable for any injuries that I may sustain, again, the knowing and voluntary requirements still apply. And as a general rule, I cannot, let's say it's a landowner, and I go on that property to engage in a certain event. Maybe I want to ride my motorcycle on that property. And they ask me to sign an assumption of risk agreement saying that I assume all risks. As a general rule, if I sign such an agreement, I cannot hold that landowner liable for any injuries that I sustain. In fact, I've got a couple of examples. I will have at least one posted for you to look at on D2L, just so you can see what a typical assumption of risk agreement looks like. And it says that the party who's engaging in this event, in the case I'm describing, the rider of the motorcycle, he assumes the risks associated with riding a motorcycle on that individual's property. And the agreement typically will say that the rider, even if he's injured due to the negligence of the landowner, as a general rule, if there's no such agreement and you're on someone's property and they are careless, maybe there are dangers on that property that the landowner knows about, they don't tell you about it, you go out onto that property, they know you're riding a motorcycle there, they don't tell you about it. Quite often the landowner can be held liable due to their negligence. They failed to warn you about those hazards on the property. However, if you sign an assumption of risk agreement, and that in that agreement you have said, you have agreed that you assume all risks and that you will not hold the property owner liable, even if your injuries are due to the property owner's negligence, then you will not be able to recover when you are injured. Again, even if the property owner has been negligent, and that is what caused your injuries. Now, an assumption of risk agreement typically would not apply where there are intentional torts that have occurred or any criminal wrongs. The person's not going to be able to get you to sign an agreement saying that you will not hold them liable for any injuries, and then they come out and commit a battery or some criminal assault upon you. This assumption of risk agreement will not protect the wrongdoer in those cases. So it's typically used for protection of the landowner. Maybe I want to set up a business, maybe with batting cages, and allow people to come in and practice. Maybe it's simply a batting facility where they're having baseballs thrown for them to hit by machines. And if I'm going to do that, I want to be sure that if a machine goes crazy and starts throwing 80-mile-an-hour fastballs at the person who's standing there in the batting cage, I want to have some protection. And so what I'll do is I'll get the individual, the participant, to sign an agreement saying that they know that there's a certain risks. I might even specify what some of those risks are, that there could be malfunctioning equipment, that baseballs could be thrown in directions that you don't anticipate. And so there's where I'm explaining what the risks are, so they are known by you. You assume those risks. You agree that even if I'm negligent, maybe I haven't maintained the machines as I should have. I failed to check them on a weekly basis or a daily basis. And so even if I'm negligent, if I put that clause in there that says you agree that you will not hold me liable for damages that you sustain, even as a result of my negligence, then as a general rule, you will not be able to hold me liable for damages that you sustain, even damages that result from my being careless. All right, so that's the assumption of risk defense. And the last item on the list that I want you to be familiar with is res ipsa loquitur. The last item that I'm going to address in this presentation is res ipsa loquitur. It means literally the thing speaks for itself. In cases where you've got res ipsa loquitur applicable, the defendant is presumed to be negligent if the defendant had exclusive control over whatever caused the injury, even though there is no specific evidence of an act of negligence, and without negligence, the accident would not have happened. That's the general gist of res ipsa loquitur. You might see this in defective food in a sealed container. That's one set of examples. It might be typical. Another, this one may be addressed in your book. I've seen it in one of the textbooks where they say you've got an airplane taking off from an airport and it erupts in flames and crashes. Typically that would be a situation where the thing speaks for itself. Another might be in medical malpractice cases where there is a missing scalpel. That's a case where the thing speaks for itself. The defendant is presumed to be negligent under those circumstances. Just know generally what res ipsa loquitur is, what it means, and that'll be sufficient for that particular subject.